Hey everybody, it's Sean Henricksen here from the Sean Henricksen Law Firm. When you get arrested for DWI, in almost all cases, DPS is working on suspending your driver's license also. So they can suspend your driver's license if you consent to a breath test and your blood alcohol level is 0.08 or higher, or they can suspend your driver's license if you refuse a breath test or a blood test. Now, that doesn't cover all circumstances. So if you are arrested and you consent to a breath test, but your test is below 0.08, then your license does not get suspended. But that doesn't necessarily mean that they're not going to charge you, that the state's not going to charge you with DWI. What I've seen them do a lot of times is if your breath is below 0.08, they will get a blood test anyway, and they will search your blood to see if you have any sort of drugs that could have made you intoxicated in your system. And so consenting, even if you are below, doesn't make everything go away. Once you are released on bail, or even if you stay in jail, you get a temporary driving license, and you've got 15 days from the date of the arrest to ask for a hearing to try and prevent DPS from suspending your driver's license. And I recommend that everybody does that. So most likely DPS is probably still going to be able to suspend your driver's license. Even if you contest it, what DPS has to show is a very low bar. So they don't have to prove anything beyond a reasonable doubt. They're just looking at whether it's more likely than not that the officer had probable cause to arrest you for DWI, and whether it's more likely than not that either you refused a blood or breath test, or you consented to that test and your blood or breath was 0.08 or higher. And so the license is probably going to get suspended, but there's a huge benefit to having the hearing anyway. In most cases, we don't have the opportunity to talk to an officer beforehand to find out what their side of the story was and to find out what all went into their determination that you were intoxicated. At a driver's license hearing, however, we can subpoena that officer, have him come in, and basically depose him on everything related to that stop and that arrest and that investigation. And in a lot of cases, officers are making mistakes. They're not doing field sobriety tests correctly. They are pulling people over without reasonable suspicion to pull them over, and they're making that arrest decision without getting probable cause to arrest you. And so that doesn't help much as far as the driver's license hearing goes, but it can help us a lot determine whether or not this is a case that you should be taking to trial. And if it does go to trial, it helps us immensely because we've already got the officer's side of the story on the record. We know what that officer is going to say, and the prosecutor doesn't. And also, if he does try to change his story at all, because he's talked with the prosecutor and they've prepared him for trial, if he changes his story, we can show that his story is not lining up, and that can call his credibility into question. So if you were arrested for DWI, your license is probably going to be suspended, but you need to fight that suspension anyway so that we can question that officer, which will put your DWI in a better case. If you have any questions about that, feel free to give me a call. My phone number is 210-900-2806. Have a great day, everybody.